Hello, and thank you for joining us today for an overview of the workplace violence and harassment legislation. My name is Lisa Kavanagh. I'm a Health and Safety Advisor trainer within the Prevention Services Department of Workplace NL, and we're delighted to collaborate with Linda Sagmeister from the OH&S Division of Digital Government and Service NL today as we discuss workplace violence and harassment. So just a little bit about Workplace NL. Serving approximately 13,000 injured workers and 17,500 employers, Workplace NL administers an employer-funded, no-fault insurance system that promotes safe and healthy workplaces, provides return-to-work programs, and offers compensation to injured workers and their dependents. Further to that, Prevention Services, the department that I work in, is made up of a group of health and safety professionals that focus on promoting OH&S education and awareness with employers and employees in our province. So some of the services that we provide include working with employers with high claims costs to help them reduce injuries at their workplaces, providing statistics on employer performance and other measures of safety, developing OH&S resources, publications, workshops, and webinars for workplaces, developing training standards, approving training programs for certification, and certifying persons who meet those standards, assisting occupational health and safety committees, worker health and safety representatives and designates to increase the effectiveness of their duties. We provide education and direction to employers for the prevention of occupational disease and musculoskeletal injuries. So there's a whole host of services that Prevention Services can provide, and one of these is the Learning Series. So the Health and Safety Learning Series is a program designed and delivered by staff at Workplace NL to increase the education and awareness of occupational health and safety and return to work in the workplace. So the series includes workshops and webinars. Unfortunately, in current times, in-person workshops are on hold, but we are offering an extensive list of webinar topics for 2021. Today's webinar is part of the Learning Series, and you can visit workplacenl.ca to view a list of the upcoming webinars, the offerings, and there's also a list of offerings included in the handout section of this webinar. So before we begin, just a couple of housekeeping items need to be reviewed. So about every 30 minutes or so, we will take a little micro break. I will encourage you to change position, move around if possible, essentially just get the blood moving, blood flowing. There is a handout section, and it contains a PDF copy of today's presentation, as well as a resource and references page with contact information. Please feel free to download this for future reference. Asking questions is encouraged. You can type them into your chat window, which is toward the bottom of your webinar panel on the left-hand side of your screen, and the questions will be answered within 24 hours. They'll prompt to us after the webinar is over. There's also an evaluation. I encourage you to complete that evaluation. It is prompted after the webinar, and that feedback helps us develop better and more meaningful workshops and webinars. You may also list any future topics of interest. So if there's something that we haven't offered or may have offered in the past that you'd like to see again, you can certainly let us know. I will now pass the presentation over to Linda Sagmeister with the OH&S Division of Digital Government, and Service NL. And Linda will guide us through an overview of legislative changes and requirements related to harassment and workplace violence.
Thanks, Lisa. So as you know, my name is Linda Sagmeister, and I'm an Occupational Health and Safety Officer and an ergonomist with Digital Government and Service NL's Occupational Health and Safety Division. This webinar will review the occupational health and safety regulations pertaining to the current violence and harassment prevention requirements. As some of you know, there were changes in the beginning of 2020, and that's what this is helping to explain. And some of you might be here as a result of needing the training for harassment and violence prevention in the workplace. So this information in this webinar is sufficient to meet the requirements of training on harassment prevention for employers and employees, like is required by Section 24.2 of the regulations, but it does not include information specific to any company's harassment prevention plan, like a specific company. So it does not meet the requirements of that part of Section 24.2. In any case, there'll be more training requirements discussed later on in the presentation as well. Digital Government and Service NL, Occupational Health and Safety Division's explanation guide provides more detailed information on harassment prevention regulations. There's a link to the guide on the slide that you can see here, and there's also one in the handout section that you can have a look at as well. But in any case, it is actually helpful to review the explanation guide and the current Newfoundland and Labrador Occupational Health and Safety Act and regulations in conjunction with this webinar. So today we're going to look at a number of learning topics. They're all here on the screen for you. They include things like where to find a copy of the legislation, a summary of the changes that came into force on January 1st, 2020, definitions of violence, harassment, and family violence, examples of what is and isn't harassment, risk assessment requirements, maintaining confidentiality, third-party investigations, worker, supervisor, and employer responsibilities, training requirements, the role of Digital Government and Service NL Occupational Health and Safety Division, as well as other agencies like the Human Rights Commission and Law Enforcement and Workplace NL. So links to the online resources referenced during the webinar will be provided at the end as well. An up-to-date official version of the Newfoundland and Labrador Occupational Health and Safety Regulations, including the January 1st, 2020 Violence and Harassment Amendments and additions, can be found at the link shown at the bottom of this slide, and they are also provided at the end in a slide at the end of this presentation as well. All right, so what's changed? So as many of you probably know, there was a violence section already included in the Occupational Health and Safety Act, in the regulations in 2009. So as of January 1st on 2020, changes to the regulations came into force, which actually expanded the definition of violence in the workplace. And they added the requirement for employers to prevent and stop harassment in the workplace. Family violence also was added as a specific risk, and additional considerations were added to the violence risk assessment process. We're going to go over all of those changes in this webinar. The requirement for employers to develop a harassment prevention plan, attend and provide training, and investigate instances of harassment in the workplace, among other changes related to violence and harassment, also came into force. So changes are identified and explained, as I said, throughout this webinar. The previous requirements for violence were found in the Newfoundland and Labrador Occupational Health and Safety Regs in section 22, 23, and 24. So as of 2020, the regulations were amended. Sections 22 and 23 were repealed and substituted, and then there were additions made also to section 24. On January 1st, 2020, the definition of violence in the workplace changed to remove the provision of the violence to be exercised by someone other than a worker. That means that violence or harassment now exercised by anyone against a worker in the course of performing their duties is the responsibility of the employer to address. The definition of violence can be found in section 22(1), and it means the attempted or actual exercise of physical force to cause injury to a worker, and it includes threatening statements or behavior which gives a worker reason to believe that he or she is actually at risk of injury. The definition of harassment as found in the regulations, section 22(2), is inappropriate vexatious conduct or comment by a person to a worker that the person knew or ought to have known would cause the worker to be humiliated, offended, or intimidated. Vexatious means causing or tending to cause annoyance, frustration, or worry, and some similar words or synonyms could be annoying, irritating, irksome, displeasing, infuriating. The Human Rights Act 2010 prohibits harassment on the basis of specifically defined circumstances, and those are called prohibited grounds. So we'll discuss those in a little bit more detail on the coming slides. But harassment which is not based on prohibited grounds is typically referred to as personal harassment, which we'll also discuss. Any type of harassment in the workplace is not acceptable, and it must be prevented as required by the Newfoundland and Labrador Occupational Health and Safety Regulations. All right, let's talk about the prohibited grounds. In the Human Rights Act of 2010 prohibits harassment based on the prohibited grounds, and those are defined in the Act. The OHS regulations definition of harassment encompasses any kind of harassment, whether or not it's based on prohibited grounds. Harassment based on prohibited grounds includes any inappropriate conduct, comment, display, action, or gesture by a person that's made on the basis of race, color, nationality, ethnic origin, social origin, religious creed, religion, age, disability, disfigurement, sex, sexual orientation, gender identity, gender expression, marital status, family status, source of income, and political opinion, and constitutes a threat to the health or safety of the worker. Harassment based on prohibited grounds also extends to sexual harassment, which is conduct, comment, gesture, or contact of a sexual nature that is offensive, unsolicited, or unwelcome. Examples might be a direct or implied threat of reprisal for refusing to comply with a sexually oriented request, unwelcome remarks, jokes, innuendos, propositions, or taunting about a person's body, attire, sex, or sexual orientation, displaying pornographic or sexually explicit pictures or materials, unwelcome physical contact, unwelcome invitations or requests, direct or indirect, to engage in behavior of a sexual nature, or refusing to work with or have contact with workers because of their sex, gender, or sexual orientation. Personal harassment is sometimes referred to as bullying, and it also includes any inappropriate conduct, comment, display, action, or gesture by a person that adversely affects a worker's psychological or physical well-being, that the perpetrator knows or ought to reasonably have known would cause the worker to be offended, humiliated, or intimidated, and that constitutes a threat to the health and safety of a worker. Personal harassment typically involves repeated occurrences and can be seen as a pattern of behavior. A single incident might not constitute personal harassment but if it's serious or severe and it's shown to have a lasting harmful effect on a worker, then it can. So you need to be very aware of the pattern that people have of their behavior in the workplace. A one-time incident of intimidation or offense may be worked out between people, but if it continues and goes on and it constitutes a pattern of behavior, you're likely looking at personal harassment. It includes things like verbal or written abuse, or threats such as insulting, derogatory, or degrading comments such as name calling or insulting jokes or gestures, refusing to work or cooperate with others, deliberate misgendering by referring to a person using terms or pronouns that do not align with the person's affirmed gender, physical or psychological bullying, which creates fear or mistrust, or which ridicules or devalues the individual, such as fist shaking or yelling. Exclusion, isolation of individuals, or withholding or giving incorrect information. Posting or sending offensive or intimidating messages via social media, email, text, phone calls. Making unreasonable demands that set up an individual to fail, thereby interfering with their work. Unjustifiable interference with another person's work or work sabotage. Spreading rumors, malicious gossip, or personal ridicule. Displaying or circulating offensive pictures, interference with or vandalizing personal property, or taking away work or responsibility without cause. You can see through the list here that personal harassment isn't always the obvious. At times, it can be a pattern of behavior that actually affects your ability to do your work, and where it is done on purpose, that also constitutes personal harassment. So what's not harassment? That's as equally important to know. Reasonable actions taken by an employer or a supervisor while managing and directing workers are not considered to be harassment. Reasonable actions considered to be part of a manager's or supervisor's work functions include things like aligning work, scheduling, job assessment, work performance evaluations, inspecting workplaces, implementation of dress codes that could be for safety or for business attire norms, implementing health and safety measures, taking disciplinary actions, such as dismissing, suspending, demoting, or reprimanding with just cause. So if it's done reasonably and fairly, then the action should not be considered to be workplace harassment. Differences of opinion or minor disagreements between coworkers are also not generally considered to be workplace harassment, but they can turn into harassment if they're not resolved, which is why these things need to be addressed as soon as possible. Likewise, difficult conditions of employment, like professional practice limitations or Organizational changes or financial restrictions are not considered to be harassment. Work-related stress as a result of any of these things in and of itself is not considered to be harassment. Management actions must be carried out in a manner that's reasonable, respectful, and not abusive. Furthermore, actions do not constitute harassment if they arise out of a relationship of mutual consent. Respectful workplace banter, interactions, and behavior that are considered to be the norm, like a respectful comment on someone's outfit, would not be considered to be harassment unless there's a power imbalance. Other situations that do not constitute harassment could include physical contact necessary for the performance of the work using accepted industry standards, conduct which all parties agree is inoffensive or welcome, or disagreements in the workplace that are not based on one of the prohibited grounds. Since January 1st, 2020, employers are required under the regulations to take every precaution reasonable in the circumstances for the protection of workers once there is awareness, or ought to be awareness, that family violence could likely expose a worker to physical injury in the workplace. The term family violence has the same meaning in the OHS regulations as it has in Section 3 of the Family Violence Protection Act. And there it states that family violence means one or more of the following acts or omissions committed against an applicant or a child by a respondent. That would be an assault that consists of the intentional application of force that causes the applicant to fear for his or her safety but does not include an act committed in self-defense. An intentional, reckless, or threatened act or omission that causes either bodily harm or damage to property, or that causes a reasonable fear of bodily harm or damage to property. Forcible physical confinement without lawful authority, sexual assault, sexual exploitation, or sexual molestation, or the threat of either of these. Conduct that causes the applicant to reasonably fear for his or her safety, including following, contacting, communicating with, observing, or recording a person. The phrase ought reasonably encompasses both a subjective and objective element. The phrase is best explained by considering that even if a person is not aware that his or her behavior is unwelcome, if that person, if a reasonable person in that same situation would have known that the behavior was unwelcome, then it's considered to be that that person ought reasonably to have known that his or her behavior was unwelcome. Examples of possible means to prevent family violence in a workplace include contacting and working with a police agency to develop an appropriate plan of action, especially communicating with the worker in question to find out what they need, and communicating with other workers in the workplace as well regarding what they should do if they witness violence or they think it's likely to occur. Ensuring that workers are not working alone wherever possible, and if it is required that they must work alone, then the working alone policies need to be strictly implemented, enforced, and adhered to. Violence risk assessment also was required in the previous regulations, and in Section 22.2, it was required that they were to do that where there was considered to be a risk from violence to be present in their workplace. But as of January 1st, 2020, every single business in the province, which is provincially regulated, has to conduct a violence risk assessment regardless. Both the previously referenced violence risk assessment and the 2020 assessment in Section 22.11 A, B, and C stated that the risk assessment must include consideration of things like previous experience in the workplace, occupational experience in similar workplaces, the location and circumstances in which work might take place. So if you're doing a violence risk assessment and you find that in your own history or past in the organization there has been robbery, or there has been any other type of violence, threat of robbery even, then that needs to be included in your new risk assessment. And if places that you are similar to, so other retail locations or other personal care homes maybe, or other businesses that are similar to yours have experienced some type of violence, take that information as well and use that in your own risk assessment. The two new required considerations that were added in 2020 were subsections D and E. The workplace characteristics, including demographics, culture, and the presence of new workers, should now be considered when performing the risk assessment. This helps to identify possible triggers for harassment and to identify possible means of preventing it from taking place. The other new requirement is to consider issues raised by the Occupational Health and Safety Committee, the Worker Health and Safety Representative, or Workplace Designate, which significantly enhances the effectiveness of the assessment, making it more tailored to the workplace. And you can imagine that that would be the case where they would bring you specific information about the location that they're working in. Employers should be prepared to show occupational health and safety officers who are performing an inspection how the input from these groups has been gathered and included in the risk assessment. Section 22(1)(2) requires employers to protect the confidentiality of information obtained in the course of conducting a violence risk assessment. Personal information is information or an opinion, including information or an opinion forming part of a database, whether true or not, and whether recorded in a material form or not, about an individual whose identity is apparent or could reasonably be ascertained from the information or opinion. Where a risk of injury to workers from violence is identified by the risk assessment performed under Section 22(1)(1), the employer must establish procedures, policies, and work environment arrangements to eliminate the risk to workers from violence. Where elimination of the risk to workers isn't possible, the employer shall establish procedures, policies, and work environment arrangements to minimize the risks to workers. Once the risks are identified and documented, then possible means of addressing each of the risks need to be identified. These are referred to as preventive measures or controls, and they should be recorded in the same violence risk assessment document. And that document is most often kept in with the Occupational Health and Safety Program. It doesn't have to be, but if there's where the violence section is in the program, it should at least reference where the assessment is. Some of the risks that are identified in the risk assessment might already be in, some of the controls that are identified for those risks might already even be in place, but others still might need to be established. So for the required controls that are not in place already, the risk assessment document should clearly show who is responsible for ensuring that the controls are put in place and by what date. The document should then be revisited. It has to be revisited actually to follow up on any outstanding actions and to ensure that all the risks have been appropriately addressed. And from time to time, it should be revisited in any case as part of the health and safety program. Employers need to be prepared to show an occupational health and safety officer how the Occupational Health and Safety Committee, Worker Health and Safety Representative, or Workplace Designate was engaged in the violence risk assessment process. Under Section 24(1), an employer shall inform workers who may be exposed to the risk of violence of the nature of the risk and the precautions that may be taken. The duty to inform workers in subsection 1 includes a duty to inform information related to the risk of violence from persons who have a history of violent behavior and whom workers are likely to encounter in the course of their work. Informing workers can take place in staff meetings, toolbox safety talks, Occupational Health and Safety Committee meetings, and any other types of communication used at a workplace or a combination thereof. Documenting that this communication has taken place is helpful for keeping track of what information has been disseminated, when, and in what manner, and to whom. There's been no change made here, as sections 24(1) and 24(2) are exactly the same in both the previous and the current regulations. So now we're on to the harassment prevention plan. Section 24.11 of the current OHS regulations requires every employer to develop, implement, and maintain a written harassment prevention plan. And this needs to be done in consultation with the Occupational Health and Safety Committee, worker representative, or workplace health and safety designate. A harassment prevention plan is required regardless of the results of a risk assessment, and it's required for every single employer that falls under the authority of the Newfoundland and Labrador Occupational Health and Safety Act and regulations. This is regardless of the size of the business. The harassment prevention plan is required to include statements on commitment, obligations, and responsibilities of employers, supervisors, and workers. It also has to include detailed procedures, so people know how to report harassment, how to respond when it's been reported, and how to provide people with information about notifications, so the results of the investigations and what's going to be happening as a result. Employers are required to develop and provide procedures for accessing an external third party, for instances where an employer or a supervisor actually is the alleged harasser. The procedures, and therefore the harassment prevention plan, must be accessible at all times so that in cases where these circumstances exist, the complainant, which is the person filing the information, is aware of and can follow the process for reporting without asking someone else to help them. Section 24.12A of the revised regulations requires the harassment prevention plan to include a statement that every worker is entitled to employment free from workplace harassment. It's very simple. An example of a plan, the plan could state all workers are entitled to work free of harassment at ABC company. Section 24.12B requires that the harassment prevention plan include a statement that the employer is committed to eliminating, where possible, or otherwise minimizing the hazard of workplace harassment. For example, the plan could state, management at ABC company is committed to providing a safe, respectful, and harassment-free work environment for all staff and customers. No one has the right to harass anyone at work or in situations related to employment with this organization. The harassment prevention plan must include a statement that the employer will protect workers from retaliation and provide support to workers when workplace harassment occurs. For example, the plan could state, ABC company will protect workers from retaliation and provide support to workers when workplace harassment occurs. At this point, the plan could then provide examples of the types of supports that the employer is likely to provide. So, for example, it could state, employees who have been affected by workplace harassment may be supported by reconsideration of shift scheduling, access to an employee assistance program, relocation of a worker to help separate workers where necessary, or other supports as deemed necessary in the circumstances. Of course, these are really only just examples for purposes of this webinar, and any organization might have some other support to offer as well. It's important to recognize that the term worker, as defined in the Newfoundland and Labrador Occupational Health and Safety Act, includes any person engaged in an occupation. So that means that the term worker actually includes supervisors, managers, and owners of organizations. These workers, supervisors, managers, and owners, might also be specifically referenced separately in the Act and regulations where they have duties over and above every other worker. So we'll provide some examples of that. In any case, Section 24.12C also requires the harassment prevention plan to include a statement of the worker's obligation. Now remember that the worker's obligation here is everybody, to take reasonable care to not engage in bullying or workplace harassment, to report observations or experiences of bullying and workplace harassment, and to comply with the harassment prevention plan. So that means that anybody in any organization is also required to report when they see harassment take place in the workplace, even if they are not the target. We'll talk about that a little bit more again later. The plan could state, workers have the responsibility to treat each other with respect and not engage in bullying or workplace harassment. We ask that anyone who experiences harassment or sees another person being harassed, report it to your manager immediately. Section 24.12D requires the plan to include a statement of a supervisor's obligation to ensure the health and safety of workers, including the supervisor's obligation to apply and comply with the harassment prevention plan. So, for example, the plan could state, managers and supervisors are responsible for a safe work environment free of harassment. The employer, supervisors, and managers are required to apply and comply with the harassment prevention plan and associated procedures. Section 24.12 requires that the plan set out the procedures for workers to report instances of harassment to an employer or supervisor, or where the employer or supervisor is the alleged harasser, the procedures to report harassment to an external third party. For example, the plan could state, if you believe you're being harassed, tell the person harassing you to stop if it's safe and if you feel comfortable to do so. You can do this in person or in writing. If you cannot deal with them directly, or if your request is unsuccessful, follow the procedures for making a formal report of harassment. This plan could then outline the procedure for reporting harassment. So an example of that would be, complete the harassment report form. The forms can be found on the ABC company intranet under Occupational Health and Safety. Provide the report to your supervisor. If the harassment is by the employer or manager or your supervisor, report the situation to the XY HR company at the following email address or phone number. Note that in this example, the procedure does explain where to find the harassment report form, and it also provides specific details on how to contact an external third party where it's necessary to make a complaint in that way. Employers are required to develop detailed procedures with contact information for accessing an external third party for instances where an employer or supervisor is the alleged harasser. Those procedures have to be included in the employer's harassment prevention plan, and they must be readily available to all staff at all times, so that in cases where these circumstances do exist, the complainant is able to access and follow the process on their own. So an external provider should be someone who's not a direct report for an employee, so not their supervisor or manager or their lead hand. And the person or organization should be removed from the work, so not in the same work unit, and needs to be an impartial response to the report. So whoever is named as your external party needs to be able to possibly do the investigation without having any responsibilities for directing work for the people that they are investigating. In some organizations, that might be a person even internal to the organization, but who, due to the size of the operation, is outside of many of the work units. So for some cases, it might be human resources in a large multi-location retailer, or where this isn't possible due to the division of work or the size of an organization, the party might actually be a truly external party. So some examples of types of organizations include, but of course aren't limited to, a legal firm, a human resources firm, a professional association, or there are companies also that actually specialize in receiving and dealing with harassment reports. The company's harassment prevention plan must also set out the procedures to be followed after a complaint of workplace harassment is received and the manner in which a complaint is investigated. For example, the plan could state, once the complaint has been received, it'll be investigated thoroughly and promptly by the HR manager within the following timelines. When a complaint is received, a meeting will be scheduled with the complainant within 5 business days to begin the investigation process. Employers are required to investigate complaints of harassment. Any employer may choose to hire a service provider to perform investigations, or they may complete them internally. Investigation procedures must follow industry best practice. And those need to be laid out as well in the harassment prevention plan to some degree to be able to show how an investigation will take place. The plan must set out the procedures regarding notification of results of investigations and any actions to be taken as a result of an investigation. So the results would be whether or not harassment has taken place, and then there might be controls put in place, as we talked about earlier, or some kind of actions to address that fact. So for example, the plan could state, when the investigation is complete, the HR manager will inform the person who filed the complaint and the alleged harasser of the results of the investigation within 1 week, either in person or by telephone. Employees who are found to have harassed another person will be subject to corrective action by the employer. Corrective actions include, but are not limited to, and here's where an employer could list what kinds of corrective actions could be considered. So these would normally be similar to or even the same as an existing disciplinary procedure for the company, or it might add some types of corrective actions such as a public apology or further relevant training. Section 24.1.2G requires the plan to include a statement that any information obtained relating to workplace harassment, including personal information, will not be disclosed unless it's necessary for the purpose of an investigation, corrective action relating to the complaint, or where required by law. For example, the plan could state the company and its managers will not identify a complainant, an alleged harasser, or any circumstances about a complaint, including personal information, to anyone unless it's necessary for the purpose of the investigation, for corrective action relating to the complaint, or where required by law. Depending on the circumstances, an OHS officer may issue an order for a harassment investigation report to be provided division for review. This is one of those examples where it is required by law, according to that section. Employers must address how they will maintain the confidentiality of all parties involved. Section 24.12 requires the plan to include a statement that the harassment prevention plan is not intended to discourage a worker from exercising his or her rights under the Human Rights Act 2010, the Criminal Code of Canada, or any other law of the province of Canada. So of course that statement could be in the plan itself, as in saying this plan is not intended to discourage a worker from exercising his or her rights under the Human Rights Act 2010, the Criminal Code of Canada, or any other law of the province or of Canada. Any worker might approach the Human Rights Commission or a police agency or Digital Government and Service NL's OHS division, or all three of these, independently of their company's harassment reporting system. Depending on the circumstances, some harassment may be of concern to all three of these agencies, and all three of them could conceivably be performing their own investigation simultaneously with that of the employers. That's because each of these agencies enforces a different act from one another, and they look for different things when they do their investigations for different purposes. In some cases, there will not be a case for human rights or for the police. However, it is a choice of any worker to contact them to consult with them about the circumstances. And we'll touch on this a little bit later in another slide. Section 24.13 states that the harassment prevention plan shall be accessible to all workers in the workplace and reviewed as necessary, but at least annually. 24.14 states that an employer shall investigate complaints of workplace harassment. The employer is obligated to investigate formal or informal complaints of harassment, including when an employer, quote, ought reasonably to know, unquote, that harassment is happening in the workplace, even though no formal harassment complaint has been made. Once somebody becomes aware of harassment in the workplace, it needs to either be reported or investigated, depending on who's aware of it. As per section 24.14 of the Occupational Health and Safety regulations, employers are required to investigate complaints of workplace harassment, as mentioned. As noted earlier, the regulations require the employer to develop procedures for accessing an external third party for instances where the employer or supervisor is the alleged harasser, and the procedures must be included in the harassment prevention plan. Where an occupational health and safety officer considers it necessary, they might order an impartial third party investigation of a complaint of workplace harassment as per section 24.15. That decision would be based on a number of circumstances, including but not limited to the quality of the investigation already performed by an employer or their representative at a workplace. So for example, the investigation might be found to be lacking or not to sufficiently address the complaint, or to have been done without using industry best practices, and therefore for complete impartiality and fairness. The cost of the third party investigation will be the responsibility of the employer, as stated under section 24.16. As per section 4 of the Newfoundland and Labrador Occupational Health and Safety Act, employers have the general duty to ensure, where it's reasonably practicable, the health, safety, and welfare of his or her workers. And then there are other specific duties also listed in the Act under section 5. A copy of the Newfoundland and Labrador Occupational Health and Safety Act and regulations is required to be readily accessible to all workers at the workplace. Employers should already be familiar with the general and specific duties of employers, supervisors, and workers according to the Act and the regulations. Every employer has the specific legal obligation to ensure, as much as reasonably practical, that workers are not exposed to harassment with respect to any manner or circumstance arising out of employment. This duty extends to incidents that occur at the workplace or during work hours, conduct perpetrated by another employee, so a coworker or supervisor, or the employer, conduct perpetrated by someone other than an employee but with whom the worker is required to meet, including clients, contractors, or the public, and incidents that occur outside of the usual workplace or after work hours that arise out of or are connected to a worker's employment, like a work-sponsored social event or a conference. Here's a summary of employer responsibilities where violence and harassment prevention is concerned. Conduct a violence risk assessment, establish procedures, policies, and work arrangements to eliminate the risk to workers from violence, develop, implement, and maintain a harassment prevention plan, maintain confidentiality, set out the procedures for workers to report instances of harassment, including the procedure to report instances to an external party where the employer or the supervisor is the alleged harasser. Participate in training related to harassment prevention. Provide training to employers regarding harassment prevention and the employer's harassment prevention plan. Set out the procedures to be followed after a complaint of workplace harassment is received. Set out the manner in which a complaint is investigated. Set out the procedures regarding notification of results of investigations and any actions to be taken as a result of the investigation. Protect workers from retaliation and provide support to workers when workplace harassment does occur. Make the harassment prevention plan accessible to all workers in the workplace at all times. So for example, don't leave it in an office which is locked during night shift when people are still working there. Review the harassment prevention plan at least annually or as needed. Investigate complaints of workplace harassment. Pay for any expenses relating to an investigation by an impartial third party if it's ordered by an OHS officer. A complaint can be made against an employer, supervisor, or worker for violation of occupational health and safety legislation. The intent of the new provisions is for the employer to deal with the complaint internally where it has to do with harassment. The employer plays an important role in modeling respectful and professional behavior at the workplace. Employers should use effective management practices to clearly define tasks, roles, and workload, promote fairness and openness in the workplace. This will also lend itself to avoiding harassment complaints being made where regular managerial tasks are being undertaken. Employers could look beyond what's legally required and take additional action to create a respectful working environment, which might include proactive training on topics like respectful workplace, diversity, and conflict resolution, and they might even consider implementing the CSA Standard Z 1003 on psychological health and safety in the workplace. For more information about that standard and how to implement it, Workplace NL also provides webinars on that topic. As per Section 5.1 of the Occupational Health and Safety Act, a supervisor is responsible to ensure the health and safety of all workers under their supervision. They're assigned an important role in health and safety, including the prevention of harassment in the workplace. To successfully implement a harassment prevention plan and most other OHS safety related plans and programs, supervisors have to set an example in their own behavior, and they need to address poor behavior in others as it is observed in a timely and respectful manner. They're responsible for applying the employer's harassment prevention plan and complying with it and enforcing it at the workplace. All supervisors must also take reasonable care not to engage in bullying or workplace harassment, report observations or experience of bullying and workplace harassment, and participate in the harassment training and participate in training about their employer's harassment prevention plan. As per Section 6 of the Newfoundland and Labrador Occupational Health and Safety Act, every worker has the general duty while at work to take reasonable care to protect his or her own health and safety and that of workers and other persons at or near the workplace. In the context of harassment, all workers, including supervisors and management staff, must take reasonable care to not engage in bullying or workplace harassment, to report observations or experiences of bullying and workplace harassment, to comply with the plan, and participate in training regarding harassment prevention and the harassment prevention plan itself. Occupational health and safety regulations require that employers participate in training relating to harassment prevention. That's Section 24.21, and that employers subsequently provide training to employees in that regard and on their own harassment prevention plan as well. All employees must be trained. Training for employers and employees can be received from a variety of sources. Some organizations actually already have in-house expertise on harassment, and they can be used to provide the information to staff in an appropriate manner. Some organizations may need to have some of their management team members or the owners attend outside training to obtain the information they need. Employer representatives who attend the training about harassment prevention as required by the regulations need to be in a position to influence the organization in terms of harassment prevention, implementing the harassment prevention plan, and who can set examples by way of their leadership and accountability. Training can come in a variety of formats, such as webinars like this one, seminars, external training providers, and others. Training will be expected to include some basic components related to harassment and how to prevent it and deal with it in the workplace. Examples of some of the basic components include clearly defining harassment in the workplace, clearly outlining the effects of harassment and how to identify it, identifying what an investigation must achieve, reviewing the need for confidentiality, and reviewing the basic requirements of a harassment prevention plan. Training for employees will be expected to include some in-person or at least electronic in-person contact where discussion can be held to pose and answer questions pertaining to the information. Providing staff with a copy of the harassment prevention plan and asking them to sign a form stating that they've read it is not considered to be adequate training and will not be acceptable for the purposes of compliance with this regulation. So there are other kinds of training, such as fall protection or confined spaces, that are actually prescribed by Workplace NL, and this harassment training is not one of those. If you need more information on training requirements for this part of the OHS regulations, have a look at the document OHS Requirements for Learning About Workplace Harassment Prevention. There's a link provided to that document in the handout section. So all workers need to know about the harassment prevention plan. All workers need to know where it is located so that they can locate it any time. They need to understand what information it includes, how it pertains to them as an employee, who is responsible for the plan's maintenance, and how it will be implemented, especially if they're working in a multi-employer worksite. They need to know what the role of the union will be where there is one. They need to know what kind of support or that they can expect from the employer, including management in the organization, both during and after an investigation into an allegation. Know how to make a harassment complaint, like to who are we supposed to make it to, what's the method we used, where are the forms located, and then what to expect once a complaint has been submitted. They need to know that they must report harassment and bullying should they witness it at the worksite, and what to expect once a report's been submitted. They need to be provided with information on their own legal obligations in the workplace where harassment prevention is concerned. The role of a Service NL Occupational Health and Safety Officer is to visit any provincially regulated workplace at any time without notice to perform an inspection. During the inspection, the employer's compliance with the Act and the regulations is actually being assessed, and it includes workplace violence and harassment provisions. While doing the inspection, things like production of documents might be required, and we might ask to speak to employees individually without anybody else around. And the point of doing all this is to enforce the Newfoundland and Labrador Occupational Health and Safety Act and regulations where contraventions are identified, and that's where employers will receive orders that are issued with an inspection form. Afterwards, there's follow-up with an employer to make sure that they are actually compliant with the legislation, that they have complied with the orders. And we also respond to occupational health and safety complaints, including complaints regarding harassment and violence. We do investigate workplace accidents, including incidents of violence, and where harassment is concerned, we investigate the employer's process that they use to investigate or deal with situations where harassment is concerned. So an officer might order that an employer investigate an allegation of harassment, or we might order that a third-party investigation be performed. In any case, an OHS officer will typically not investigate an actual allegation of harassment itself, because that is clearly the responsibility of the employer as per the harassment prevention plan requirements. As previously noted, the employer's harassment prevention plan must include a statement that the plan is not intended to discourage a worker from exercising his or her rights under the Human Rights Act 2010, the Criminal Code of Canada, or any other law of the province or Canada. The Human Rights Commission and law enforcement do have their own roles and responsibilities. Their activities might parallel that of Digital Government and Service NL for any given allegation. The Human Rights Commission does investigative allegations of harassment based on the prohibited grounds as defined under the Human Rights Act and previously outlined in this webinar. Police will investigate allegations of criminal harassment, including stalking, sexual and physical assaults, uttering threats, or damaging another person's property. These are criminal acts that must be investigated as criminal matters. Even if somebody has contacted the Occupational Health and Safety Division, and if we are investigating something, police should still be called in those situations, and preferably first. Criminal harassment, like stalking, is defined as harassing behavior, including repeatedly following, communicating with, or watching over one's home. At this point, I'm concluding this part of the webinar. We've reviewed violence and harassment sections of the Occupational Health and Safety Regs, as well as the responsibilities associated with them. At this point, I'd like to turn this over now again to Lisa Kavanagh for more information about Workplace NL's services.
Thank you, Linda. Some great information there. So yeah, a little bit more about the services at Workplace NL. Basically, the role of Workplace NL is to provide education and create awareness about the OH&S legislative requirements for employers. So we offer webinars like the one you're attending today, workshops and education information sessions specifically at your workplace if requested. We're here to provide guidance and assistance through resources, education, and information to help you meet those legislative requirements that Linda has outlined. If you have any questions, would like more information, or would like to avail of any of the services, you can email workshops@workplacenl.ca or email me directly at lisa.kavanagh@workplacenl.ca. So a little bit about some of the resources that we have. One of the most frequently received comments from employers in our regular work is, how do we complete a workplace violence risk assessment? And the Workplace NL created this guide, the Workplace Violence Risk Assessment Process, and it was developed in response to that specific request. It outlines a 4-step process to completing a violence risk assessment, including identifying the hazards, evaluating the risks, finding solutions, and implementing or making recommendations. And there's kind of an overall, an overarching piece to this that's a continuous monitoring and evaluation loop. As we implement things, we need to determine if they're working the way they should, or if things need to be further adjusted. So the guide also includes samples. They're listed here on the screen. The employee survey, this tool can help provide valuable information about what hazards exist in the workplace with a risk of violence. So the survey is completed by employees, and it helps to gather information related to the perception of violence, possible problem areas within the organization, as well as areas like interactions with clients and members of the public. And the survey focuses on previous incidents of violence in the workplace, the types of interactions with customers or clients or the public, high-risk activities, and types of violence occurring in the workplace. Then there's the work environment questionnaire. There's a sample in there as well. And it's a sample, and it's meant for, I guess, all industries. It was kind of designed to incorporate everything. So there may be pieces in there that are applicable to your organization and maybe pieces that are not applicable. And essentially, it allows for a comprehensive look at the work environment and the work tasks that are completed. So the purpose of that questionnaire is to gather information about the risk factors for workplace violence by identifying, the tasks involving public interaction, the risk factors, are there any staff working alone, and a thorough physical worksite review. So kind of like a workplace inspection with a violence lens. And your inspection, it's an inspection of all areas considering the risk of violence. The information gathered from both the employee survey, the work environment questionnaire, those things will help to identify the hazards that exist in your workplace and help you to populate that into the risk assessment tool that's provided there. The guide also includes a sample workplace violence policy, as well as a violent incident report form. So the guide is available online at workplacenl.ca, and there's a link provided on that resource page that is in the handout section as well. And if you have any trouble finding it, you can certainly contact me. There is a second guide. The recent legislative changes that now require an employer to develop, implement, and maintain a harassment prevention plan has prompted us to create this guide. So it's Workplace NL's Harassment Prevention Guide, and it was developed to assist in the process of developing, implementing your harassment prevention plan. And every organization is different, and this guide is merely meant to be a resource as well. So it's not a cookie cutter approach. Things need to change based on the setup and your organization itself. So this includes a sample harassment complaint form, sample guidelines for investigations, a sample harassment prevention plan, and some fact sheets, checklists of items to be included in the harassment prevention plan and things of that nature. This guide is also available online at workplacenl.ca. And again, there's a link on the resource page in the handouts. So again, Workplace NL staff are available to consult with you and guide you through the process of completing a workplace violence risk assessment and a harassment prevention plan. We also offer other webinars related to these and other workplace violence and harassment topics. And you can visit workplacenl.ca for a full listing of webinar offerings. And I believe there's also a link in the handout section that will link you to our webinars. So at this point, I'm going to hand it back to Linda, and she'll give you some information about her department and as well some resources.
Thanks, Lisa. I just wanted to mention about these resources here very quickly that, well, the first one is for the regulations, and a copy of the regulations in the Act, as I mentioned earlier, is required to be on site. So if you don't have a published Act and regulations from the Queen's printer, you can use the one from online in the interim, and that's where you can find it. The Occupational Health and Safety Division Explanation Guide is really useful, I think, or I've been told at least that it is, and we hope that it is. We also update it quite a bit. So when people contact us and have questions and want us to include that in the explanation guide, we are more than happy to do that. The link is right there. It's for part 3 of the regulations, which is where the harassment and violence prevention sections are. But there are other parts in there as well that you can see for other parts of the regulations. So if you are wondering about if there is an explanation guide pertaining to a different section, you're welcome to go there and see that as well. We do update it somewhat regularly, so it is worth having a check to see when it is updated. And there's a date right on the front of the chart that shows you when it most recently was done. So it should be fairly simple to do. Lisa just talked to you about the Workplace NL Risk Assessment Resources resource guide and the harassment prevention guide. We use that extensively. We hand it out to a lot of people. We refer people to it. They're both excellent resources, and they help a lot to get through these parts of the regulations. And the Family Violence Prevention Act obviously speaks for itself, and you can see the link there. But if you're looking for the full definition of family violence, you'll find it in there. Okay. So the next thing I just want to talk about quickly was occupational health and safety with Digital Government and Service NL. We used to just be called Service NL. Now it's Digital Government, if you're wondering. And at this point, I just wanted to let you know, I guess our mandate, which is our primary goal, is accident and illness prevention. We recognize that all workers have a fundamental right to a workplace that neither impairs their health or imperils their safety. And it's achieved by working with stakeholders to establish, promote, and enforce workplace practices, standards, and procedures. Relevant to harassment, if you are calling us with a complaint or looking for information about harassment, those are usually directed to specific officers in the division who've been assigned to address harassment issues. You can call any of those numbers there of those locations. It doesn't matter which location you're calling. It's still going to be sent to those specific officers that are dealing with harassment right now. And when you contact the division at any of those places, they will send your call over to one of those officers, but it may not be possible. And if that's not possible at the time, then they'll try and take your information and give it to, or they'll send you over to a manager. If they can't find a manager or any officers at the time, which does happen from time to time, depending on how many field visits are going on right then, they will want to take your information so that somebody can contact you as soon as possible and get back to you. If you're not comfortable doing that, please let the person know, and you can feel free to call back soon and try again, or you can just give them some information about a workplace and leave it anonymously, and we can try and follow up from that regard as well. So I just wanted you to know that information. And if you want to contact OHS to report an act of violence at work, you can also use the Serious Workplace Accident Reporting line to do that. But if you're in danger or if you need immediate assistance as a result of violence, please call 911 or the police immediately. Lisa?
Thanks, Linda. So I'm going to finish it off here now with a little bit of contact information for Workplace NL. So we've got 3 offices across the province: Corner Brook, Grand Falls, and St. John's. The contact information for each of these is listed on this slide. There is also a toll-free number, 1-800-563-9000, which will connect you with the appropriate office or person based on your inquiry. As mentioned earlier, if you have any questions or require assistance as you complete your workplace violence risk assessment or your harassment prevention plan, you can certainly reach out to us at Workplace NL, or you may call me directly at 778-1544 or reach me by email at lisa.kavanagh@workplacenl.ca. As well, we can facilitate OH&S education sessions for your workplace on these topics, the workplace violence, harassment, respectful workplace topics, or many other OH&S related topics. Just touch base with us. So at this point, the webinar is concluded. If you have forwarded questions throughout the webinar into your chat box, we will respond to them via email within 24 hours of the webinar ending. If you'd like to follow up with us, if you have any other questions, you can certainly email or contact us by phone through the contact information that's provided on the handout sheet. I'd like to thank you for your participation today. Thank Linda for her collaboration with us in providing you with the legislation and the workplace violence and harassment legislation overview. Thank you and have a great day.